Welcome everyone to today's session. For those who don't know me, I do recognise a few names, but for those who don't, my name's Karen Mosley. I'm the Director for Professional Standards and Complaints. I'm going to be facilitating this session, but thankfully you won't hear a lot from me. It'll mainly be from Duncan and Pat. Also assisting in the background, we've got Kendra. She's the Manager for Professional Development and Programs. Most of you will probably have had some kind of communication with her as well. If you're having any issues or you need any support, reach out to either of us in the chat. We do have a few other from ACSL in the background as well if you need anything. Before we get going, I just wanted to recognise that I'm facilitating this session from the Bundjalung country. And I also want to recognise that the traditional custodians of the various lands on which you're joining us from today, both within Australia and those internationally, because I do know that we've got some from overseas as well. We honour the First Nations people, culture and connection to land, sea and community, and we pay our respects to their elders past, present and emerging. I also wanted to acknowledge the lifelong trauma of abuse victims and survivors and their families, and the failure of the Catholic Church to protect, believe and respond justly to children and adults at risk, and the consequent breaches of community trust. Before we move into the session with Duncan and Pat, I just wanted to take the opportunity to do a little bit of a pitch for our next webinar. So for anybody who's interested, on the 22nd of November, we have Associate Professor Tim Moore, who's presenting Bridging the Gap, working with children, young people and vulnerable groups in safeguarding efforts. Details on that is through the LMS, and there'll be communications coming out shortly as well. We're also currently working on our session for next year, and hopefully more information will be out about that soon. If you have any thoughts on the things that you would like to hear, we're more than welcome suggestions to come through. We're happy to have a look at those. One final little disclaimer, today's discussion should be focused on legal and canonical principles, but discussion can take us into places where content can be confronting. So make sure you prioritise your health. If you find anything challenging, take a break, take the time you need, look after yourself first. So today we're welcoming the Honourable Duncan Kerr, former federal judge, and Dr. Pat Mullins, who's a partner at Mullins Law, to discuss balance of probabilities and moral certainty. And I nearly forgot to say doctor, because I just wanted to congratulate Pat, who's recently successfully defended his doctoral thesis overseas. So Duncan was a judge of the Federal Court of Australia from 2012 to February 2022. He served as president of the Administrative Appeals Tribunal, and prior to his appointment to the Federal Court of Australia, he practiced as a barrister specialising in public law, constitutional and administrative law, refugee and human rights law and appellate work. Duncan is also the chair of our National Appeals and Review panel, and has been working with ACSL on that. As I mentioned, Pat is a partner at Mullins Law. He's Australia's only canon lawyer who simultaneously practices as a common lawyer, and has an understanding of the church which equips him to act for Catholic authorities in matters involving both common law and canon law. So and Duncan and Pat might mention this themselves, but today we're going to open the conversation around legal and canonical principles. What's going to be discussed is not necessarily legal advice. So if you face yourself in any situation where you're not sure, we do suggest that you still get your own legal advice and you don't necessarily refer solely on this webinar for that position. As I said a little bit earlier, although some may have missed it at the very start, because of so many people, if you've got any questions or comments, pop them in the chat. We'll go through them and collate the questions as we go. We'll try and get through as many as we can, depending on time. So you probably don't want to hear from me anymore. So with all of that being said, I will welcome Duncan and Pat.
Thank you. The way we'll proceed is that I'll provide what I hope will be an interesting discussion about the history and development of the way in which the burden of proof in civil matters has developed in Australia. And Pat will give a comparison paper on canon law, and hopefully we'll have enough time for some questions. But I should start by saying that the law of evidence and questions of the standard of proof was until 1995, with the enactment of the Uniform Evidence Acts, which now apply in the Commonwealth and most states, nearly exclusively a matter of judge-made common law. And in criminal proceedings, the standard of proof was and remains beyond reasonable doubt. Now, that's a cryptic expression, and it's well settled that judges in trials are not allowed to expand on what it means. Juries are told that the expression beyond reasonable doubt is a common sense term, and they're to apply it. And no further explication of that term is permitted, even though it is one of the most commonly asked questions of judges by jurors. But the reticence to explain that expression is a relatively recent phenomena. In the case we're going to look at a little lot closer, Briginshaw and Briginshaw, which was a decision of the High Court in 1938. And for those of you who want to read it, it's at 60 Commonwealth Law Reports at 336. Chief Justice Latham, who was in dissent in the result, but not really material to this point, said this of the criminal burden of proof. He said, in criminal cases, it's long established that there must be a moral certainty of the guilt of the accused. The presumption of innocence must be definitely displaced either by direct evidence of facts which constitute the offence charged, or by evidence from which the jury can draw an inference which satisfies the mind beyond reasonable doubt. So the use of that expression, moral certainty, with its strong echoes of ecclesiastical jurisprudence, would not have been particularly surprising to lawyers in 1938. For much of England's legal history, there were parallel common law and ecclesiastical courts. And in the ecclesiastical courts, the standard of proof that was required before a finding of serious delinquency could be reached was that of moral certainty. Now, of course, everybody knows that in 1534, Henry VIII broke with Rome, but until that time, a very significant part of the judicial power of England had been exercised exclusively by the ecclesiastical courts applying Roman canon law with a final appeal to the Pope. Henry VIII's religious revolution did little to change the day-to-day operation of England's ecclesiastical courts. They continued to operate as much as they had before, but rebadged under the authority of the Church of England, with the Crown as its titular head. A right to appeal to a new court called the High Commission was substituted for an appeal to the Pope. And at the village level and town level, archdeacons' courts seamlessly continued to exercise jurisdiction over things we'd now classify as minor crimes, such as common drunkenness and moral delinquency, such as prostitution. The higher ecclesiastical courts continued to have exclusive jurisdiction in respect of matrimonial issues and things like wills and probates. The ecclesiastical courts allowed legal representation only to members of what are called the Doctors' Commons, that is, lawyers who had taken a civil law degree from Oxford or Cambridge. Secular common law barristers were not permitted to appear in those courts. But over time, the ecclesiastical courts were brought into the main judicial stream. But it was a very slow process. The major turning point occurred in 1857, when the English Parliament passed both the Matrimonial Causes Act and a Court of Probate Act. The former act defined the circumstances in which a marriage could be dissolved and set up a court of divorce and matrimonial causes to exercise the former ecclesiastical jurisdiction. A court of probate was established to deal with disputes about wills and intestacy. Now, rights of practice in those courts were opened up to ordinary barristers. But in the nature of things, old habits die hard, and much of the substance and practice of law in those new courts was influenced by its earlier civilian or ecclesiastical history. Now, Australia adapted or adopted much of that English tradition in the colonial times, and when Australia federated, the Constitution gave the federal parliament authority to legislate with respect to marriage, but it was slow to do so. The courts that were exercising secular judicial power in England and Australia with respect to matrimonial causes had never reached a clear position as to the burden of proof required to make findings of fact in matrimonial proceedings, particularly where those proceedings involved a requirement to establish the truth of an allegation of grave moral sin. Now, Victoria enacted its own Marriage Act in 1928, which broadly reflected the English legislation of 1857. And the case that we are looking at, or I will be looking at and discussing, Brigginshaw, can best be understood in a context of the High Court seeking to impose a more systematic order on Australia's legal system. So what was the issue in Brigginshaw? It was a question of what standard or standards of proof or satisfaction applied to civil, non-criminal proceedings in matrimonial causes, particularly those which involved an allegation of moral failing. And if you look at Brigginshaw, you'll see that the cases that are referred to by the court show that that issue had remained a murky one. Now, Brigginshaw, the facts of that was that Mr. Brigginshaw had applied for a divorce on the basis of his wife's alleged adultery. He'd set up a private investigator, various ways to find out what his wife was up to when she was living alone in Devonport in Tasmania. So there's a Tasmanian connection. But the nature of an allegation of adultery in 1938 was still freighted with a gravity of immorality and sinfulness that our increasingly secular society finds difficult to understand. The divorce proceeding came before Justice Martin of the Supreme Court of Victoria, and he heard evidence that Mrs. Brigginshaw had spent an evening with a person who the husband named as a co-respondent. Mr. Brigginshaw led evidence that the co-respondent had made an explicit admission of adultery. However, later he had denied that, and an independent witness had confirmed that denial. In his reasons, Justice Martin explained that he had been deeply troubled by how to decide the case. He said that all of the witnesses had given their evidence well, and he could discover nothing adverse to them about their demeanour. And he concluded his judgment like this: I do not know what to believe. I have been very much troubled. I have done my best to decide, but the petitioner must satisfy me that his story is true. I think I should say that if this were a civil case, I might well consider that the probabilities were in favour of the petitioner, but I am certainly not satisfied beyond reasonable doubt that the evidence called by the petitioner should be accepted. Now, Mr. Brigginshaw appealed to the High Court on the basis that Justice Martin had erred in applying the criminal standard of proof in a civil proceeding. All of the judges in the High Court agreed that the Brigginshaw matter was a civil proceeding, it's a divorce proceeding under the Victorian Act, that there was no intermediate standard of proof in Australian law between the civil and criminal standards, and that in all civil proceedings, the standard of proof was that of satisfaction on the balance of probabilities. But they differed in the outcome. Chief Justice Latham reasoned that because Justice Martin had expressly applied the criminal law standard to a civil case, Mr. Brigginshaw must be entitled to win his appeal and have his case reheard according to law. He pointed out in his reasons that the learned trial judge had not actually considered the evidence according to the proper and relevant standard of proof. Now, that seems a perfectly logical conclusion. So how could Mr. Brigginshaw have lost as he did? Now, it's mere speculation on my part, but my inclination is that the other judges who made up the majority thought that whatever error Justice Martin had made, the result that he had reached was sound. They didn't want to just send the case back to be reheard by another judge and to be decided on a mere technical or mechanical weighing of the preponderance of probabilities, as they thought Justice Martin had been correct to have resisted. But to do that, they had to clarify the law. Doing so took some judicial gymnastics. It first involved recharacterising Justice Martin's apparent understanding that the case he had decided was not a civil proceeding. Each of the plurality then chose to read his Honour's reasoning as if he had not simply been persuaded by the evidence that would have allowed him to reach a verdict in Mr. Brigginshaw's favour on the balance of probabilities. Justice McTiernan said of Mr. Brigginshaw's key contention, excuse me, it is based on a misunderstanding of the learned judge's observations. It assumes he treated the case as a criminal trial in which he was bound to apply the criminal standard of proof. But it is apprehended that the purpose of this observation was not to indicate that the trial was criminal as distinguished from civil, but to indicate it was not a case in the mere preponderance of evidence would suffice to establish the petitioner's allegations of adultery. Now, the critical judgment in Brigginshaw was given by Justice Dixon. It's been a lasting set of reasoning. Justice Dixon turned what Justice Martin had said in the trial almost on its head. He reasoned much to the same effect as McTiernan. He said, my own interpretation of what he said is that not only had the evidence fallen far short of satisfying his mind beyond reasonable doubt of the adultery alleged, but that he had not formed an actual belief that the adultery took place, although he thought possibly he might consider that the probabilities disclosed by the evidence were greater in favour of that conclusion than against it. Now, what Dixon then said regarding the way a judge is to apply the civil standard of the balance of probabilities remains good law. 1938, rare to have a decision that has stood the test of time as much as what His Honour said in this case. So I will read a passage, but I've shortened it a lot, and you can go to the original judgment should you wish. What Dixon said is this: the truth is that when the law requires the proof of any fact, the court must feel an actual persuasion of its occurrence or existence before it can be found. It cannot be found as the existence of a mere mechanical comparison of probabilities independently of any belief in its reality. Reasonable satisfaction is not a state of mind that is attained or established independently of the nature and consequence of the fact or facts to be proved. The seriousness of an allegation made, the inherent unlikelihood of an occurrence of a given description, or the gravity of the consequences flowing from a particular finding are considerations which must affect the answer to the question whether an issue has been proved to the reasonable satisfaction of the tribunal. In such matters, reasonable satisfaction should not be produced by inexact proofs, indefinite testimony, or indirect inferences. This does not mean that some standard of persuasion is fixed intermediate between the satisfaction beyond reasonable doubt required upon a criminal inquest and the reasonable satisfaction which a civil issue may, not must be based on a preponderance of probability. It means that the nature of the issue necessarily affects the process by which reasonable satisfaction is obtained. When in a civil proceeding a question arises whether a crime has been committed, the standard of persuasion is the same as upon other civil issues. So we've just seen an example of that with the defamation proceedings that Mr. what was his name?
Lehrman.
Pardon?
Lehrman. Bruce Lehrman.
Yeah, Mr. Lehman brought in this in federal court. But weight is to be given to the presumption of innocence and exactness of proof is expected. The extreme caution and the usual positiveness of persuasion, however, required in criminal cases do not obtain. Now, what Justice Dixon said in those passages remains good law in common law jurisdictions and also in those states which have adopted the Uniform Evidence Act. Section 140 of the Uniform Evidence Act reflects the Brigginshaw approach. It says, in subsection 1, in a civil proceeding, the court must find the case of a party proved if it has satisfied the case has been proved on the balance of probabilities. Subsection 2 says, without limiting the matters the court can take into account in deciding whether it is so satisfied, it is to take into account A, the nature of the cause of action or defence, B, the nature of the subject matter of the proceeding, and C, the gravity of the matter alleged. Now, if those principles under the Evidence Act do not create a third standard of proof depending on the seriousness of the allegation, they simply direct a judge to consider those factors that may fairly deprive him or her of feeling an actual persuasion that a particular event occurred. If they don't form such an affirmative opinion, he or she cannot be relevantly satisfied on the balance of probabilities. Now, a recent example in the space affecting the church of the application of those principles is a case of BYM and Corporation of the Trustees, Roman Catholic Archdiocese of Brisbane, number 2. In that case, a young woman alleged she had been sexually assaulted by a groundkeeper employed by a Catholic school authority. The court applied the Brigginshaw principles in holding that the evidence before it was insufficient to generate on the judge's part an actual persuasion that the wrongdoing had occurred as had been alleged. Now, an important point I want to make is that the Brigginshaw principles are rules of evidence. They apply as matters of law only to matters heard and determined in courts, or in a rare instance in which the law requires a tribunal to apply them. And almost all administrative tribunals and investigative proceedings are not bound by the rules of evidence. Usually that's expressly so. And in a case in the full court of the federal court, Justices Flick and Perry referred to approval to what was said in a case in the AAT, where the rules of evidence are statutorily excluded or do not apply, not bound by the rules of evidence. They explained what that means. In Tarrant, the AAT had observed that that's the statement that the tribunal is not bound by the rules of evidence is not a grant of a power to occasionally depart from the strict application of the rules of evidence. Rather, it presupposes and establishes a scheme for the tribunal to inform itself of relevant matters in which, subject to the rules of natural justice, it may rely on any probative matters which are relevant to its function. Now, that was a statement in a case called Sullivan and Civil Aviation Authority, and it's reported at 2014 FCA FC 93, passages at paragraph 11. Sullivan approving that approach. And Sullivan itself is an example of the key point that the Brigginshaw principles, as a matter of law, do not govern the conduct of a body which is not bound by the rules of evidence. The case involved a decision of the AAT to have removed an experienced helicopter pilot's license, and it had dismissed that the AAT had been required to apply the Brigginshaw principles to his circumstances because of the very real seriousness of the allegations against him and the risk that his career would be shattered should he lose his license. Now, when the matter came before the AAT, it had applied the reasoning of Justice Madgwick in an earlier case, which is called CASA, Civil Aviation Safety Authority, and Boatman, 2006 FCA 460. And in Boatman, Justice Madgwick had reasoned this way. He said, as to the ease with which the court should be satisfied of matters adverse to them, the respondents submitted that given the seriousness of the consequences for their reputation and livelihood of adverse findings, the evidentiary principles of Briginshaw are applicable. I disagree. The proceedings are primarily protective of the public, notwithstanding that fairness to impugned authorisation holders is an important part of the process. It would be inconsistent with the statutory commands to the court to consider reasonable grounds to believe and to give safety the primary emphasis, to require that the court only acts on proofs which are not inexact, testimony which is not indefinite, and inferences which are not indirect, referring back to the Briginshaw statements of Dixon. Now, Mr. Sullivan invited the full court of the Federal Court of Australia to hold that Boatman had been wrongly decided, and it declined to do so. The plurality, Justices Flick and Perry, held at paragraph 61, any unquestioning analogy between administrative and judicial processes is to be shunned. And they cited there a case that decided in the High Court, Minister for Immigration and Ethnic Affairs, and Wu Shan Liang. And in that case, Chief Justice Brennan and Justices McHugh and Gummow had observed this. They said, submissions were made at the hearing of the appeal as to the correct decision-making processes which would have been permissible for the delegates that were delegates of the Minister for Immigration in that case, but applying generally to people exercising non-judicial administrative or investigative functions. These submissions were misplaced. They drew too closely on analogies to the conduct and determination of civil litigation. Administrative decision-making is of a different nature. As with the term evidence as used to describe the material before the delegates, it seems to be borrowed from the universe of discourse, which has civil litigation as its subject. The present context of administrative decision-making is very different, and the use of such terms provides very little assistance. So, noting the purpose served by the Civil Aviation Act was not to punish pilots who had erred, but to maintain, enhance and promote the safety of civil aviation, Justices Flick and Perry reasoned that in exercising its power to cancel Mr. Sullivan's helicopter pilot's licence, the decision-maker had to take into account both his interests and the broader public interest, but not in a mechanical way that applied the Briginshaw principles. So the AAT had not fallen into error in failing to do that. Now, it's important to note that that's not to be said that an administrative decision-maker has a licence to proceed unfairly. Rather, it means that the bounds of an administrative body or a non-judicial decision-maker or an investigator's responsibility to act fairly is not defined by the rules of evidence, but rather is set by the purpose of their authority, the nature of the proceedings, and by the decision-maker's obligation to accord interested parties procedural fairness. And in procedural fairness, the main two elements are the hearing rule, that is, making certain that the person who's made aware of the allegations against them has an opportunity to respond, and the bias rule, that is, the tribunal doesn't hold any, is not affected by any prejudice or inclination one way or the other in favour of his opponent or her opponent, rather than a duty to apply the rules of evidence. However, it's important to also observe that there's a third element now that allows administrative decisions to be set aside, and Australian law has come to recognise what it calls legal unreasonableness as a discrete basis for setting aside decisions which have been made on the basis without any plausible, credible basis. So it is not unreasonable for a decision maker, an administrative decision maker, to reflect on the Brigham-Shaw principles by analogy, because you don't want to fall into the trap of your decision being held to be legally unreasonable, particularly in reaching a finding involving a finding that somebody has committed an act which the community would generally condemn, such as fraud or reprehensible conduct, such as the abuse of a child. Sometimes, as a matter of common sense, the logic of the Brigham-Shaw principles are useful, provided that the decision maker understands that they are not to be applied as legally binding and not to be applied unthinkingly. So an example of that is, as Justice Logan in Sullivan pointed out, as to the difference in the seriousness of the evidence required for a decision maker to conclude that a person has deliberately lied, as compared with merely finding that their evidence was unpersuasive and could not be accepted. A warning to all of us that a finding that we need to have much more serious grounds to make a finding that somebody has deliberately lied, as opposed to simply rejecting their evidence on the basis that that it is unpersuasive for various reasons. It logically doesn't fit with other facts or the like. The use of the Brigham-Shaw principles in those kind of circumstances simply reflects Lord Brougham's rhetorical but common sense submissions when he was defending Queen Caroline in the House of Lords when she was charged with adultery. He said of that, "The evidence before us is inadequate to even prove a debt, impotent to deprive of a civil right, ridiculous for convicting of the pettiest offence, scandalous if brought to support a charge of any great character, monstrous if to ruin the honour of an English queen." It just makes the point that, just as a matter of common sense, we recognise that we do need to approach more serious matters with a greater degree of seriousness. But in respect of the work of the investigators under the National Response Protocol and that of the reviewers in the National Appeals and Review Panel, the starting point for all of us is that neither of our work, nothing of our work forms any part of Australia's judicial system. And we and they are not bound to apply the rules of evidence. Moreover, we and they work in a space that has been expressly designed by the church authorities to redress earlier failings and to be protective of the public. It can, in that context, be readily accepted that a serious adverse finding made by an investigator or the National Appeals and Review Panel will have serious consequences for an individual priest or member of the laity working in a Catholic institution against whom an allegation has been made. However, it is well past the time when the cloth a person wears or their status can shield them against findings of misconduct. And so the reasoning of the full court of the Federal Court of Australia in Sullivan is, I apprehend, to be the correct lens of analysis to apply to that work. It means that we do not ignore that seriousness, but equally we recognise that it is working in a sphere where there is an obligation also to the protection of the public. Now, there is a rare and I think yet to be drawn on potential under the protocol for an investigation conducted under it to also simultaneously be used for church canon processes, or at least to the initial stages. And if such a matter was to arise, the different standards of proof in canon law and that of the civil law as understood through the lens of Sullivan might lead to satisfaction being reached on the secular side with respect to findings, yet a want of satisfaction being recorded on the canon side, where moral certainty is, I understand, the required standard of proof. Properly understood, such a possible outcome is neither illogical nor improbable. It's no different than is inherent in the secular scheme of things, such as the Lehrman case might be thought to illustrate. So even a grave finding under the protocol on the civil side is not a conclusion that a person should be removed, say, from the priesthood. Such a question must be determined within the Church's canon law, and in that context, as at least I apprehend it, findings must be made on the basis of moral certainty. But I will turn to somebody who knows much more about that than I purport to, and it's that standard that Dr. Mullins will now address.
Thank you. Thank you, Duncan. I don't want to talk about moral certainty in a vacuum, so I think it's appropriate that I look at canonical penal proceedings to see what questions the judge has to deal with in coming to his or her decision on that standard of moral certainty. To do that, my starting point historically, and I think I can get away with this since, Duncan, you started before the Reformation, by going back to the 13th century, and the legal historian Brundage says that by the 13th century, both ecclesiastical courts and civil courts in Europe followed the jus commune, and a feature of that was the Roman / canonical procedure. So it had features from Roman law, but it was the canonical procedure that was followed by both civil and ecclesiastical courts in Europe by that time. He suggests that there were a number of basic legal principles which were ingrained in the jus commune and in those procedural norms that were followed at that time. The idea of due process, I think that's a fair enough observation. The presumption of innocence, that seems to be the case. Privilege against self-incrimination. I suspect that that really has not come into the canon law until much later, and we've got the whole Inquisition, which really didn't honour the privilege against self-incrimination, or the right to remain silent, which is now ingrained in the canon law as well as the civil law. Also, Brundage suggests that the rule of law itself, as we know it now, was part of the jus commune and the procedural norms of criminal procedure in the 13th century. I think that's probably a bit of an overstatement, but nothing much turns on that. But basically, the proof of criminal guilt was said that was required at that time for imposition of a penal or a penalty was proof which must be clearer than the light of day. I think that is quite a difficult standard. Effectively, there could be a conviction and the imposition of a penalty if there was a free confession of guilt by the accused, or if there was sworn evidence by at least 2 witnesses. And that, of course, is a gospel and even a Hebrew requirement. I remember I've appeared a number of times in the Iona Passion play at Easter, and there's a great scene where Jesus is brought before the Sanhedrin, and it's quite authentic to the gospel. And there's a scene where Jesus is questioned by the Sanhedrin. In fact, there are 2 witnesses brought before the Sanhedrin, and they don't make a proper case against Jesus, and Caiaphas runs out from the room where the Sanhedrin is gathered, ripping his robes and saying, "We must have 2 witnesses, the law demands it." There was one commentator who says the voice of one witness is the voice of none. But that rule about the very strict rule about 2 witnesses being required needed to be ameliorated. And it was sometime later where the law came up with the canon law came up with the novelty of crimes that were notorious, so that they were so public that they could be the basis of a prosecution where there was neither a need for a witness nor an accuser. So that novelty of notoriety stayed with the law in canon law until quite recently. Under the 1917 Code, there were 2 ways of proceeding: the public accusatorial process, which was employed when the crime was notorious and absolutely certain, and it was for the promoter of justice to proceed in those cases. If, however, the crime could not said to be notorious nor absolutely certain, there was the mixed accusatory process, again, which was in the hands of the promoter of justice, effectively the diocesan chief prosecutor. The mixed accusatorial process under the 1917 Code was employed where neither the fact of the happening of the crime nor its criminality were notorious and absolutely certain. So there was a need then for a special investigation. And that's the precursor to what we now know in the canon law as the preliminary investigation under Canon 1717(1). The special investigation under the 1917 Code was directed to gathering the facts and considering the imputability or responsibility of the accused person for the crime. Now, under 1717 in our current code, the law demands that a matter be investigated where there is the fumus delicti. Now, my current Archbishop laughs about my Latin pronunciation, but you know what I mean by the fumus delicti. It's the smoke of a delict or a crime. If there's enough smoke, then the consequences follow. But the focus of the preliminary investigation under our current canon law is not to make any decision, because those decisions require the exercise of the judicial power. But the investigation under Canon 1717 is an exercise of the diocesan bishop's executive or administrative power. Doesn't have to be carried out by him, but can be carried out by his agent, the preliminary investigator, who he appoints by decree. So the scope of the preliminary investigation under our current code is the facts and circumstances of the matter and its imputability. For a penalty to ultimately be imposed, the crime must be gravely imputable to the accused person. And it can be imputable by reason of malice, which requires sufficient deliberation, or it can be by reason of culpability, that is criminal negligence, in the sense that there's a failure to understand that the act is criminal, but the accused has been criminally negligent by not making proper inquiry as to the situation. So malice involves a deliberate intention to infringe the law, and if the violation was intentional, then the full penalty imposed or nominated in the particular canon is to be imposed. But if the violation is by fault, that is not by a deliberate intention to infringe the law, but by criminal negligence, then a lower penalty may be imposed. The process by which the decision ultimately is reached involves the consideration of circumstances that might modify imputability, that is, exemptions. And there are certain people under canon law who cannot be criminally responsible, same as our own civil law. Then there can also be extenuating factors that need to be examined by the judge, and also assumptions of ignorance that might not excuse but explain. The delinquent is free and enjoys the use of reason, and then the criminal act then is morally imputable to its author. That's at the level of sin. But if the delinquent is free and bound by the canon law, then if the crime is the crime will be morally imputable to its author in canon law because he has an obligation to account for his actions as a church member. And so that's where the juridical element requires that the second aspect actually is that the canon itself must require a penalty to be ascribed to the transgression of the law for it to be a crime. The penalty may be indeterminate one or one that's specified in the particular canon of the code. So imputability is that property of an action in virtue of which it can be attributed to some person as its proper author. There needs to be a physical causal connection between the agent and their action. So responsibility is the relationship of the agent to another to whom he must render an account of his actions. Judicial criminal imputability is based on two fundamentals. The imputability, as we said, must be by malice or by criminal negligence. Dolus or malice is the deliberate will to violate the law, and criminal negligence we've already spoken of. The law itself raises the raises a presumption. It's the presumption that an external violation of the law raises the presumption in the external forum of the presence of malice unless the contrary is proved. So in assessing the responsibility of the offender, that is the degree of imputability, which must be grave, the starting point is to presume the person accused as innocent until proven guilty. That's the basic principle, and the judge's decision maker can't really ever leave that out of his or her consideration. The second thing is the subject baptized into the church or received into the church after baptism, because it's only those persons who can be guilty of a crime in the church. And is the subject in possession of sufficient use of reason to make him or her imputable for the crime? The other element, of course, is the age of the subject, the age of 7 is referred to in Canon 11, that's often not a great issue, but can arise in certain circumstances. The condition of the subject in the church, whether the person is a lay person or a cleric, can be very relevant to a particular delict. Certainly the delicts of child sexual abuse are reserved effectively to clerics and religious, both lay and clerical religious, but now they've been extended to include persons who are appointed to an office in the church, such that that could involve a lay person. But the condition of the person is a consideration that needs to be brought to bear. The elements then of the delict are matters for consideration by the judge. There has to be an external violation of a penal law, and it must be gravely imputable to the subject with malice or culpability, as we've mentioned. Then the decision maker must consider whether there are circumstances which modify the person's culpability, that is, consideration of exemptions, mitigating factors, aggravating factors, and even the degree of completion of the crime. So on some occasions, a crime may only be partially complete, and that comes into it as well. The judge must remove from his or her mind any form of prejudice against the accused person. The judge comes to his or her decision by only focusing on the acts and the proofs. By the time of the prosecution getting to that stage, the acts of the case have been prepared. They contain all the documentary evidence that are relevant, and they contain all of the witness testimony that's relevant. So only from those acts and proofs that are contained in the acts of the case can the judge come to moral certainty about the imputability of the crime to the accused. So he or she keeps in mind the presumption of innocence at all times, considers the evidence and testimonies carefully, discerning their credibility, their respective credibility, and then decides the degree of penal responsibility. So the assessment involves those exempting, mitigating, or aggravating factors, and we come to then the consideration of what do we mean by moral certainty. Moral certainty is in the mind of the judge. A mere preponderance of the proofs and indications is not sufficient. What is required is that any prudent, positive doubt of the making of an error in law or in fact is excluded. Not even the mere possibility of the contrary can remain. So this process of coming to moral certainty is according to the judge's own conscience. Moral conscience is in the heart of the person. It enjoins him or her at the appropriate moment to do good and to avoid evil. It deals with also and judges particular choices made, approving those that are good and denouncing those that are evil. It bears witness to the authority of truth in reference to the supreme good to which the human person is drawn. So conscience is a judgment of reason whereby the human person recognises the quality of a concrete act that he or she is going to perform, is in the process of performing, or has already performed and completed. One must be sufficiently present to oneself to hear and follow the voice of his or her own conscience. St. John Henry Newman called conscience the Aboriginal vicar of Christ. So what's required is a turn inward, which is a particular Augustinian notion of interiority, so that the judgment is made in the conscience of the judge. We know that conscience is supreme, and I think it's instructive to consider what the Holy Father Francis said to the Roman Rota in his annual address to them in January of this year. He told the judges of the Rota that if they didn't pray, please resign, because if you're not a prayer and if you don't know how to pray, you should not be a judge. He said that the decision on moral certainty is a decision reached in the judge's conscience, such that it's a process one carries out on one's knees. And later in the discussion with the Roman Rota, the instructions given again were, if you don't know how to pray, then you don't know how to make a decision in terms of moral certainty, because it's an exercise of your conscience. It involves the exercise of two of the cardinal virtues. The first one is prudence, and the second one is justice. Prudence, we know what prudence is, and that's the virtue which the judge can bring in a prayerful, conscientious weighing of all of the evidence, but in particular, those features of the evidence that are probative. He or she comes to that moral certainty in a prayerful mode, not relying on his or her own abilities, but humbly approaching the Holy Spirit for inspiration as to what the true decision is and what the only decision that can be reached is. And that's the decision based in moral certainty. And that's all I have to say on the matter.
Thank you, Pat and Duncan. That was great. I wasn't expecting the history lesson to go quite so far back, Pat, but it was good. It was a really good way to understand where these principles have come from and how they've developed. We haven't really had any questions come in through the chat. If anybody does have any questions or comments, feel free to pop them in. I personally feel like my mind is reeling a little bit. It might take me a little bit of time to come to any kind of question. Carmel has asked whether or not either of you could offer some further readings. I've taken down a couple as we've gone through, but perhaps Duncan and Pat, if you have any thoughts on what would be good for readings, you could let me know and we can distribute them to the group.
Happy to do that. I mean, it's a hard slog, but Briginshaw is an interesting case because it really involved the judges taking an instance where I think they felt if they didn't grab this opportunity to clarify the law about how a question of applying the law of civil standard of proof. Unless they grab this, there would still remain a confusion, and just doing what Chief Justice Latham proposed, sending it back to be reheard because the judge had made a mistake, didn't appeal to them. I suspect, and nobody knows the history of this, but I suspect there was a bit of a discussion between the bench, and a majority thought, well, look, we've got to try and say something that will illuminate the balance of probabilities doesn't just mean a soulless or technical application of a mechanical weighing of whether it's a slight preponderance of evidence. It involves something not quite the same as a prayerful insight, but an actual feeling, an actual apprehension of satisfaction that the matter has been established on the balance of probabilities. And then the more serious the matter, the more a court has to incline to caution. And so I think there are some sort of overlaps between the nature of those principles and that which the Church enjoins be applied in determining matters under canon law. But I'd be interested in Pat's observations about that.
Yes, Duncan, I think that really what the High Court did in Brigginshaw, as you've explained it, requiring that decision maker to feel an actual persuasion is a sort of a secular process similar to the moral certainty requirement. And the Holy Father saying it's a prayerful exercise of your conscience. And I think, they're similar exercises. So I'm quite fascinated and interested in the similarities that we can draw out of those two processes, because I think in some ways a canonical judge may well get some guidance in coming to his or her moral certainty requirement by looking at what the High Court has said, and certainly Justice Dixon in Brigginshaw, and the whole idea of the Brigginshaw principle not being a different standard of proof, but a principle that's really imposed upon the civil standard. Yeah, so I think the canonical judge could certainly get a bit of help out of reading some of those cases.
Yeah. Thank you both. Another few questions have come through, grouping a couple together. Can you offer any practical advice on the application of the balance of probabilities when looking into investigations into clergy abuse?
Well, my strong view is that the correct lens to see that is through the Sullivan approach. Sullivan was about something entirely different. It was about somebody who was licensed to fly helicopters, but they wanted to require investigators and the decision makers to use the Brigginshaw test because it was very serious as to the consequences. And, the judges really had to work around saying, well, look, in administrative law and in the sort of area outside of the courts, we don't require that kind of strictness. But we do take into account the seriousness of the consequences of the person involved, but we also have to take into account that it involves matters of public safety, and to require a strictness of proof of going close to moral certainty or anything like that It would be silly if planes are going to be falling out of the sky. I mean, if a pilot is unsafe to fly, there's a huge interest in the public to make sure they're not flying. I think there's a similar underlying principle that is now in the protocol, the way it's been designed. The church, rebounding from criticisms that it had failed to deal with some of these issues adequately, has set up a process which starts out on the basis that it is protective of the publics that engage with the church. And in turn, because it has done that, that protects the reputation of the church. So I think that the Sullivan approach is the correct one, which says strictly the Brigginshaw principles don't apply. You can take them into account by way of analogy, by saying, look, yes, there are very serious consequences, but at the end of the day, if you are satisfied that certain things have happened on the evidence before you, in an environment where you're not bound by the rules of evidence, you can take probative materials into account, you can take hearsay into account, you can take all sorts of things into account. But you have to do so with fairness and applying principles of natural justice. You do all that, you proceed, and I suppose you do feel the sense of satisfaction that the result is that these events occurred as they are alleged. Then you make that finding. And if such a finding is made, then the appeals panel endorses that finding. So I think it's, I think Sullivan provides a lens through which you can see these things. Respect, of course, to the consequences for the people against whom allegations are being made, a recognition of the seriousness, but also a recognition that there is a public purpose, that is the protection of the Catholic community and others who might be the subject of making allegations, bringing allegations to light, mean that you don't over egg the omelette. You don't over egg the omelette and sort of, in a sense, provide some kind of level of immunity to that conduct.
Carmel,
If I could, could I just add in there too, I think that the value then for the church authority receiving that report, yes, we follow the process outlined in the NRP, but the value is that if it's a bishop who needs to make a decision about whether there needs to be a canonical investigation, that's invaluable for him to receive that report. That report can feed straight into the canonical investigation, regardless of the differences in standards of proof required, because really, as we've heard, the preliminary investigation simply is a fact-finding exercise to establish the facts, and secondly, to inquire into the imputability of the crime to the person under investigation. And so then if there's that firmus delicti, then if it's a sexual crime involving a child and a priest, then it goes to Rome, to the DDF, and then the process proceeds. So, you know, really there's been a lot of argument about whether the NRP is going to imperil the rights of the priest, but those rights can and should and must be protected throughout the NRP. And if that's occurred in the investigation process under the NRP, then the priest has nothing to fear. And then it goes on through the canonical process where again, his rights have to be protected.
I just wanted to, Carmel put in a bit of a clarifying question in response to that one. And she just mentioned the seriousness of the consequences for the victim or of alleged abuse or, versus the seriousness of consequences for the accused. When you're taking the seriousness into account, is it?
I don't think you're taking the seriousness of the consequences to the victim into account as a matter of evaluation of evidence. You hopefully do it in a way that is trauma informed so that you treat a person who has made a complaint with understanding and sympathy through the process. But at the end of the day, the task of an investigator is to determine whether an allegation has been soundly made out. And that question doesn't really turn on the interests of the person who has accused him or her of wrongdoing. But all through the process, I mean, we've learned a lot about trauma-informed processes. We have to recognise that that any inquiry can be extremely damaging if badly conducted for persons who make allegations as well as those who are the subject of allegations.
Yeah.
And I think it's interesting to note in the Vos Estis Lux Mundi norms, where it talks about the investigation of a bishop by the Metropolitan, it specifically indicates that that if a child is to be interviewed, that trauma-informed processes and processes are employed to protect the child in that interrogation or interview. And I think that's really important. And the fact is that Rome has recognised that that must be done. It doesn't extend it to crimes involving priests, but if there's an investigation involving a priest and a child is to be interviewed, then obviously those processes should be followed. And, you know, they're well documented, I think, in, you know, bench books and that sort of thing, and in United Nations documents as well. So there's no shortage of knowledge about how to do that, but involving someone who's skilled in it is very important.
Absolutely. We've probably got time for another couple of questions. We've had one come in. Says, do you think that you know, there's a pendulum swing after the recommendations of the Royal Commission towards a greater focus of safeguarding is in danger of swinging back to a more legalistic approach, given the recent significant amounts awarded in compensation in historical child sexual abuse litigation matters?
Look, I think this is a really interesting little question. I know that we have discussed in the National Appeals and Review Panel meeting that the volume of work that has come through the review process has been less than historically was the case. And I think that part of the reason for that may be that with the way in which the courts have opened up the capacity to bring legal proceedings, notwithstanding the expiry of statute of limitations that used to apply, and various other circumstances have changed there, more people are seeking legal advice and are going to court. The interesting and perhaps ironic consequence is that in the courts, the Brigginshaw principles apply in their full flower. And so you can get a decision, as in the case I mentioned about the Brisbane groundsman, in the judicial setting, which perhaps if it had been pursued through the protocol process, might have had a different result, because there the focus would have been more on the issue of the protection of the interests of the larger community. I think that's possible. I don't know. I don't know the facts sufficiently to know whether the case was close to being established but didn't quite make it, or was frivolous and vexatious. I just read that decision where it was an application of the Briginshaw principles, where the court said it wasn't, ultimately didn't have that sense of satisfaction that the matter had been established, and it referred explicitly to the Briginshaw principles. I think there is a tendency for lawyers, because I think they can get more money out of it going to court and getting an award to go through that process. But also it's probably been coupled with a certain certain distance from the time when the Royal Commission happened, and the Church might itself be more prone to take a legalistic approach. I hope not. Just it's impossible for me from my distance to assess that, but one would hope that isn't the case, because the good reputation of the Church will always depend on the fact that where it is asked to exercise its internal procedures, it does so in a way which is compassionate and fair.
And I think in the NRP, those requirements of church authorities to act as a model litigant are very significant. They were there under the Truth, Justice and Healing Council's protocols about that, but they've been transposed into the NRP, and I think they're very important. And I think, from what I understand, church authorities take them very seriously, and so they should.
I might just jump in with one more. There's two questions that kind of touch on the redress scheme. Are both of you across the redress scheme enough for me to pose that question? So there's a question regarding the, I guess it's a kind of a lower threshold that the redress scheme applies than what is typically seen in a civil space. And then the other part, somebody else put in a question about the challenge that they're facing when something comes through the NRS. Quite often the victims and survivors don't want to be part of, you know, the more rigorous investigation that would be conducted internally to that civil balance of probabilities. And if you had any views on that.
Pat might have more understanding of this, because I sort of sit at the top of this review and appeal system, and things that filter up to that don't really give me a good insight as to what is happening.
Look, I can answer it. I think I have some involvement in it. It seems to me, however, that the reality is that the system is legislated. The standard of proof is legislated. These matters are determined by outside or independent persons appointed by the scheme regulator, and it effectively, the standard of proof that applies means that if there's evidence to show that the alleged perpetrator was present geographically in the institution at the time of the alleged abuse, and if there's evidence to show that the applicant for redress was there also in the institution, so that there was the opportunity, then if the person who's making the application says that he or she was abused and it's particularised, then the church authority just has to suffer the consequences of the decision, and there's nothing we can do about it.
Yeah, it's a very challenging situation sometimes, I think. So I think that's probably where we'll have to stop for today. I think we've gone a little bit over what we originally discussed, but thank you again for everything you've done today and the work that you've both been doing so far for the Catholic Church. It's definitely been Great for me personally, speaking and working with both of you. And I'm hoping that I speak for everyone when I say that they got something out of today as well.